Good morning, everybody.
Good morning, Your Honor.
Good morning. Well, welcome to an oral argument session of the 6th District Court of Appeal. My name is Judge Molly Nardella, and joining me today is Judge John Stargell and Judge Jared Smith. We are being live streamed. You should have received a warning, and this will be posted on YouTube. We have one case for our consideration today. It is IceRack LLC versus Antone Moody et al. Each side will be afforded 20 minutes to argue, and it is up to you on how to use that time. The appellant is also afforded a rebuttal out of those 20 minutes. Typically, we reserve 5 minutes unless appellate counsel states differently. Counsel for the appellant, would you like something other than 5 minutes?
If it pleases the court, and I've never seen this done before, but can I get 7 minutes for rebuttal?
We will keep the time. It's your job to watch the clock, but we will set it to give you a warning when it's 7 minutes.
Thank you, Your Honor.
Counsel for appellant, whenever you're ready.
May it please the court. My name is Ramil Kaminsky, and I represent the appellant IceRack in this matter. We're here today on a procedurally simple appeal, whether the trial court committed reversible error by dismissing with prejudice Bailey Oliver and Hannah Milligan from the underlying lawsuit. However, the greater issue here today is what legal recourse a business has against the person that publishes a single word adjective about a business because they made a choice to contribute to the collective advancement of a false narrative without any factual support. Respectfully, today I ask this court for clarity in the law, perhaps even guidance to pursue justice for small businesses damaged by cancel culture. Specifically, respectfully, I'll ask the court to confirm that justice for these businesses can be pursued in lawsuit counts like defamation, trade libel, conspiracy, civil conspiracy, and
the order on appeal hinges on a distinction between fact and opinion, and you see that throughout the case law. Do you concede that the United States Supreme Court precedent sets a clear and rigid framework that we should do the same when analyzing the opinion at issue?
In part, Your Honor, because the statements that are at issue are not opinions, and I think I understood what the court was saying, but the use of the word opinion at the end kind of threw me off. In this particular case, the statements that were made were as follows. Oliver made a statement saying, terrible and unethical business owners are running this place, period. There are many other places in Lakeland to get ice cream, period. Don't go there. So in the legal sense, the adjectives that are used are absolutely adjectives or descriptions of events. That is an opinion on its face. However, the law talks about the implication of facts or mixed or hidden facts. And in this particular case, the distinction of the opinion that is being described concerns nouns like business owners that are running the place, the verbs. So there's an action of something that's being done, that's being described, which necessarily imposes underlying facts that are hidden. And these statements that are published by Oliver, it's important to also distinguish that, yes, the Supreme Court precedent is very clear as it relates to the way that a court is to protect First Amendment rights. But it's also very clear that hate speech and attacks against reputation that are improper are cognizable at law. And in this case, it's important to distinguish that a statement that is made by Ms. Oliver is a statement independent of any of the context that we've alleged in this complaint. When a reviewer goes to look at the review that was made, the review itself appears as I've attached to the second amended complaint. If the court looks at the Exhibit A of the amended complaint on the bottom, it comes up on Facebook as Bailey Vea doesn't recommend Rita's Italian Ice and Frozen Custard 3115 with the address. So that's the first thing. That's standard. This case is not about opening the floodgates. So anybody who puts a doesn't recommend or a recommend can be sued. This case is the fact that Miss Oliver and Miss Milligan both took the additional step of not simply saying we don't recommend, but they added a post.
Counsel, what's interesting about this case is the implied fact that is provable as untrue, according to your complaint, is that Oliver and Milligan had a personal experience. Is that true? Is that your allegation, that the implied fact, which is provable being untrue, is that they had been customers or had a firsthand experience? Is that true?
In part, Your Honor, the way that, and I think this is where the appellees lost what I was saying. The argument that the personal experience goes towards the effect on the reader, because this review exists independent of any other review and independent of Mr. Moody's instruction to go and leave fake reviews. It exists on the business's Google or Facebook site by itself. So nobody knows that this is linked directly to Moody unless they're a part of the action of, unless they're involved in the whole Moody thing. So,
right. So as your argument would go, a reasonable reader would read this argument in and of itself and find that these two women, Oliver and Milligan, had a negative experience at Rita's Ice Cream.
Yes, Your Honor. And
okay.
And
so my question, counsel, is: do you have any case law where the implied fact, which is provable as being untrue, or that implied fact alone is not defamatory? Because what's interesting to me is the implied fact here is banal. It's they had an experience, they didn't have an experience. It's the description of that experience, which is the opinion, right? Which is whether or not it's defamatory, it's negative, whether or not it's actionable is a different question. But just stating that you have or have not been somewhere is not in and of itself positive or negative. And so is there any case law where the implied fact is not necessarily by itself a negative fact, although it can be provable as untrue?
Your Honor, I'm unaware of any case law, because I think that in and of itself would constitute, you wouldn't be able to prove the defamation because it needs to have some kind of injury. But I think that the court might be looking at, not looking at the actual statement. The statement says terrible and unethical business owners. To define somebody as terrible and unethical, there needs to have been some chain of events that allows you to do so. So the fact has nothing to do with their the
well,
presence.
The second statement says, use it. I don't have the statement right in front of me. I know that you do. It says, the owner was rude, or was that certainly implies a personal experience, according to your argument. So my question is, that statement is, the implied experience is not necessarily itself defamatory. That you were or were not had an experience at some place, that itself is not necessarily a negative statement.
Right, but that negative statement, that fact, goes to bolster the defamatory nature of the conduct. I think what the court is actually referencing is in the Milkovich case. It talks about, and I believe I had provided this argument, and I'm paraphrasing, Your Honor, because I don't have it in front of me right now. but it discusses the events that can lead up to determination of Jones is a liar. And that's what we have. So Jones is a liar is in and of itself appears to be an opinion, but it can't be caveated with, in my opinion, Jones is a liar in order to avoid liability. The circumstances behind why Jones is a liar is what's here. And that missing fact that the customer service was rude, they need to have had that experience in order to say that customer service was rude. Or alternatively, if it is proven at a later time. So for instance, if discovery reveals that they believe that customer service was rude because they observed or heard about the customer experience from somebody else, that would be an affirmative defense. But we're here on the procedural case, on a procedural phase, where at this juncture, given the four corners of the complaint, the validity of the positions that are being potentially articulated at a later time don't matter. What matters here is that we've alleged in the complaint that these folks had no basis to make the statement that they did. And that's what the court and the lower court respectfully didn't apply. And as this court is aware, the four corners of the complaint are the only things that can be looked at and attachments that are incorporated by reference or made a part of that complaint. And here we have the statement on paragraph 142 for Oliver and 147 for Milligan. The statement says, on or about December 22nd, Hannah Milligan represented herself as having had some type of genuine experience with Rita's Lakeland. After following ADM's instruction and or the momentum of the other defendants by posting a non-recommendation of Rita's Lakeland on Rita's Facebook page, see Exhibit B. However, at no point prior to December 22nd, 2021 was Hannah Milligan ever a patron, customer, or visitor at Rita's Lakeland. In the alternative, Hannah Milligan's non-recommendation was made in a way so that readers of the recommendation would believe her quote-unquote opinion was based on a genuine experience with Rita's Lakeland rather than a targeted attack on the business. This is the allegation that must be presumed to be true, and the trial court did not acknowledge that in its final order. And this is significant because if Hannah Milligan ultimately states that she had the basis for her opinion was not that which was alleged, then there's a different issue. But that's done after discovery. In this case, we're at the procedural phase. The court didn't even let us get to first base, and that's why I think that it's a procedural matter that should be reversed. If there's no other questions, I'd like to move on to my points. Other points, Your Honor.
Counsel, can you hear me? Okay, it's Judge Smith.
Yes, sir.
So, as I was reading through the cases, this whole pure opinion versus mixed opinion, pure opinion being non-actionable, mixed opinion being actionable. Frankly, the words that we have here, terrible, unethical, business owner, rude, would really seem to kind of push the line as far as we could possibly push it, frankly, on cutting out the free marketplace of ideas, and falling into that area that the Supreme Court said we don't, we need to protect that. I mean, I see cases where there's perjury, where somebody, mixes opinion and fact, and that brings out something like perjury, or that a judge is not going to properly judge cases, because of their sexual orientation. There was a case to that effect. I mean, these are pretty specific. I think, kind of going to Judge Nardella's point, pretty specific defamatory items that we're talking about. I didn't really find anything that went as far as the three words that I see here that you seem to be most concerned about. So I'd like to hear from you. What would you say is your best case? I've got your argument, but give me your best case that goes in line with where, somebody a court upheld a defamation case because the word rude was used, or, awful. These things seemed hard to prove, and you've got, at some level, we've got to have a provable fact. That's my challenge with your case, counsel, is I'm having a hard time discerning what's the provable fact here.
Good. Thank you, Your Honor, and I appreciate the opportunity to answer these questions, because this is exactly why I seek the certainty as a litigator, because it's undisputed that businesses get attacked by this cancel culture, and if people hide behind an adjective that otherwise has no facts
Well,
behind it.
I mean, I get that, and I would say that, to your credit, the trial court did not dismiss your entire case. You have a lot of other defendants that are still out there. You lost two of your claims here, but you didn't lose them all. So I don't feel like we would just be putting a thumbs up to the cancel culture as you have stated it. But at the same time, my question to you is very specific. What's the closest case to these three words that you've got for us?
Your Honor, I'm hitting by my 7. I'd like to change to 5. Is that okay for the rebuttal?
Oh, you can keep going. Yeah, go take another couple minutes. That's fine. If you want to answer my question now or wait.
Yes, Your Honor. I believe that, and again, I understand that there are no binding cases upon this DCA. So with that caveat, I would say that there are some instructive cases that I think are strong. They're referenced on page 16 of our brief. It's the Anson v. Paxson Communications Court matter and Scott v. Bush. I think that and then another case that I think is important is Barnes v. Horan, which is a case where they determined that it was improper to strike a pleading solely where the alleged defamatory statement is an opinion that implies undisclosed facts. The implication of undisclosed facts is what is thought of to a reader. And that's what is important, because the review section of a business's page is what's at issue. No reader who's going to look at this business's ratings or reputation, online reputation, can think that the person writing this review is not a real person or is not someone who had a genuine experience. That is necessarily something that's different. I'm not asking the court to open floodgates to one-star reviews, but what I'm worried about, Your Honor, is that upholding the underlying trial court's decision will create an interlocutory issue where the other defendants who are similarly situated, who made adjectives alone on these reviews, whether that's Google or Facebook, will utilize the either a PCA or this court's opinion to validate that position, which creates an issue of access to courts, which actually goes into my next thing. If the court is going to find that there is no defamation, no defamatory statement as a matter of law, then the single action rule must not apply, because the single action rule is and I see my time, Your Honor, thank you. The single action rule was the second reason that the court dismissed the counts outside of the defamation and trade libel. And that's something that I wanted to hit, because the single action rule has been treated as a defense to defamation. The absence of defamation as a matter of law cannot be a defense to defamation. It's either defamatory and being defended, or it's not defamatory, which can't be defended. So the single action rule cannot apply as a matter of law to instances where there's no defamation. And I say this because, Judge, if the court is saying that there is no recourse because the opinion is being made and it's not defamatory, then that necessarily goes against the rights of businesses to protect their online reputation. Because when a group of people like these folks attack a business and bring down the star ratings, that is an online reputation that exists, and there needs to be justice for that. That's why I seek this court's
Counsel, we're not going to a group of people. This case is about two people. You keep talking to a broader scale as to these two people and the words that they said.
Yes, there's a count for civil conspiracy. Sorry, Your Honor.
Right. But if these two people, if the words that they ended up using don't reach that standard, you think you still get to include them in the larger conspiracy?
Yes, Your Honor, because under the Chiraco v. Hialeah case, this Lakeland is not a big town. When you have 36 people in one day or within a span of a couple of days go and write a negative review about a business, there is a big effect that happens and to that specific business. And I think that that's what actually needs to. We keep going to what happens in the defenses that these folks might have. Let them bring their defenses, but the procedural matter is the complaint as pleaded doesn't allow them the opportunity to assume that that they're allowed to have the opinions. In the complaint, we've pleaded their inability to have the facts that they need to have an opinion on something. They might be able to present it later, but the court should not push the cart before the horse and allow them and allow dismissal at this phase. If there's no other questions or issues, I'd like to allow any time for rebuttal.
Certainly, counsel. Counsel for Appellee, whenever you're ready.
May it please the court. My name is Jesse Haskins. I represent appellees Antone Moody and Maria Angelica Martinez. I intend in my allocated time of 10 minutes to address two issues. First,
Counsel, before you start, I have a preliminary question. Does the order on appeal directly impact Mr. Moody and Mrs. Martinez? The specific order on appeal.
Under the Tipsy Coachman doctrine, Your Honor, there is an alternative basis.
Outside of the order, though.
I'm sorry?
But that would be going outside of the order. Does the order that's being brought up on appeal directly impact, affect, deal with your clients?
The order, in terms of the two statements, does not have a direct impact. However, any opinion, I think, from the court is going to have a impact also on whether my client's statements are defamatory. There is certainly, and I believe that counsel for appellant actually made this point, is that there are interactions amongst the statements and the legal analysis. But the primary point and argument I would like to make is that this is a perfect case for the Tipsy Coachman doctrine to apply. And the reason for that is both the order and anything else has to be predicated on standing. Here, there is no standing. And again, even though the order did not make that specific finding, the absence of standing is clear from the record. Actually,
not only did the order not make that legal conclusion, what findings of fact did the trial court make that support us making that legal conclusion on a Tipsy Coachman basis?
The Florida Supreme Court has recognized that the trial court does not have to make specific findings of fact. I think the best case illustrating this is the Firestone case. In Firestone, the Florida Supreme Court reviewed, quote, thousands of pages of testimony, end quote, to actually affirm. And the context of this was it was before the 1980 constitutional amendments stripping jurisdiction to consider per curiam affirmances. So the Florida Supreme Court considered before it a per curiam affirmance. There was no basis, no specific factual finding, but the Supreme Court actually reviewed the transcript in its entirety, specifically stated in its opinion that it reviewed, quote, thousands of pages of testimony, and actually applied the Tipsy Coachman doctrine. There are other cases indicating that the appellee doesn't even need to bring the matter, the factual issue, to the attention of the trial court. And the trial court—
We have due process concerns about that, counsel?
Yes, Your Honor. May I address the due process concerns? Understanding that is the primary concern. The appellant has had sufficient due process. We've raised the issue of standing, I think, at the beginning of January. And the answer brief rehearses in detail numerous opportunities where the appellant actually engaged with the standing issue. And appellant, obviously, in the course of briefing, has addressed the standing issue as well. But most tellingly, the plaintiff has actually conceded that it has no standing, and I'm going to quote, "The plaintiff has no standing to allege brand damage." That is a quotation from counsel for appellant, and it appears on the record on page 4,493, lines 7 to 10. So I think in due process, the concern is whether a plaintiff could strategically prolong a lawsuit by omitting the document that its action, that its standing is based upon. Plaintiff has had numerous opportunities and in fact has exercised the opportunities to try to raise factual issues and contest the issues of standing. And in fact, I think the main item that the appellant in exercising its due process rights has pointed to is a lease rider. But this lease rider, again, brought up by appellant, I would emphasize, exercising appellant's due process rights, the lease rider actually says that it is the franchise agreement that, quote, "governs the development and operation of Rita's Italian Ice." And so even evidence essentially gathered and relied upon by appellant in contesting the issue of standing supports the appellee's position. There is, I think, absolutely been sufficient opportunity for the appellant to raise the issue of due process. The concern and the issue that the Tipsy-Coachman doctrine seeks to address is this idea of appellate efficiency. The term appeared most recently in the Freeman case, included in the notice of supplemental authority, and it was actually quoting the Florida Supreme Court case, Robertson. And so I think the issue is, if appellant has had since January to explain, to produce evidence, I don't even think their appellant can point to requesting any document that could possibly be used to contest the issue of standing. Every opportunity and document produced, every document relied upon by the appellant has pointed to the complete absence of standing. And that is the simplest issue. It would avoid the need to continue to litigate, obviously, in the trial court and to produce an appeal every time that there is a new statement, when the entire complaint against all of these 37 defendants, I believe it's 37 defendants, suffers from the same lack of the same fatal defect. And I also, I think, just sticking with this issue of simplicity, another example of this is in the Neves versus Senior Health case. There, the trial court denied leave to amend the complaint because of an interaction between the relation back doctrine and a new statute, I believe. But the appellate court, the second DCA, saw, quote, "a less complex way to affirm," again, finding lack of standing. WQBA, a Florida Supreme Court case, the appellee can present any argument supported in the record, even if not expressly asserted in the trial court. All the cases relied upon by the appellant involve more complex factual issues, where I think due process is more of a consideration, because the appellant was essentially deprived of due process opportunities to develop the factual record. In Winnow versus Workman, for example, the appellee asked the court, the appellate court, to find fraud on on the court. And in that case, the court found an evidentiary hearing is required. And in featured property, the issue was meaningful appellate review is made impossible by the absence of specific findings. I'm sorry. And I would yield. I understand there's a total of about 10.5 minutes left for appellees collectively. And so I would yield the balance of my time to Mr. Cantor.
Mr. Cantor, whenever you're ready.
Good morning. May it please the court. Andrew Cantor on behalf of Bailey V, aka Bailey Oliver and Hannah Milligan. As the court may have noted in the pleadings and in appellant's brief, the statement or posts, I should say, made on social media by the appellees are couched in the term as non-recommendations. To be honest, that's clearly just circumventing calling them opinions, okay? Appellant's counsel conceded that the appellees did not reference the facts in chief, ironically, which I believe bolsters the appellee's case. Whether the appellees were weighing in on a public dispute because they knew some of the other defendants involved, whether it's because the manager of the restaurant went on Facebook Live and streamed, complaining about the incident to the public at large, or for whatever reason they decided to state their opinions, they're pure opinions and they are protected under the law. Counsel,
Mr. Cantor, let's engage in a thought experiment. What if your clients had gone on and they had explicitly said what was arguably implied? What if they said, I went to Rita's yesterday, and while I was at Rita's, I had awful service, and I thought the owners were just horrible people? What if they had said that? Where are we?
I believe we're in the same place, Your Honor. The fact is all the cases, and then I appreciate the court doing a little bit of the heavy lifting for me, Your Honor. But as I believe Judge Smith stated earlier, all the cases that the main cases cited to by appellant's counsel, Milkovich, Scott v. Bush, Anson, Barnes, and Hock, if I'm saying that right, or Hoke, they all have statements of verifiable fact that were made about the plaintiffs in those cases.
What do you say to the fact that there is a verifiable fact stated? I went to Rita's. Let's say that's untrue, which is alleged in the complaint. And take that a step further. That verifiably untrue fact bolsters the opinion.
Fair enough, Your Honor, but that's not a defamatory statement about Rita's. So I don't believe that falls in the same penumbra as the other fact patterns, because those fact patterns revolve around the defendants making specified facts in public directed at the plaintiffs, making a false, some sort of potential falsehood. Milkovich, which is, I believe, the case that's most relied on by appellant's counsel, he stated, Milkovich lied at the hearing after having given his solemn oath to tell the truth. So a specific statement was made by the publication, the newspaper, stating that during a judicial proceeding that the plaintiff committed perjury. That was not done here. And I can reread the statements for Your Honor, but I believe you've heard them ad nauseum at this point, and they're obviously within the brief. But they make statements about how they're rude and awful, and that they're terrible and unethical. Those words, Your Honor, are subjective terms. I've met people before that I thought were the rudest people ever, but somebody I know goes, "Oh, I love that person." Well, okay, but it's an opinion. You cannot verify somebody being rude or awful or terrible or even unethical, even though to some degree there are, ethics that may or may not be shared within certain communities, but what's ethical to one person is unethical to another. So with respect to what appellant's arguments are, there's very concrete distinctions being made within the fact patterns of those cases, whereas here we have very nebulous terms being used. And again, as conceded by appellant's counsel himself, they don't even reference the subject incident. So there's nothing to verify. It's somebody saying, I don't like that person, and then posting it online, and there it is. And the case law is very clear on that, Your Honor. I cited to, I believe, law offices of David Frieden, which is a persuasive case from the Seventh Circuit, in which it says reviews on Facebook and Google do not purport to provide any factual foundation or clearly meant to express the opinions of defendants. Broad terms lack the necessary detail for it to have a precise and readily understood meaning. There are
But wouldn't a
numerous.
reasonable reader here use especially the statement which uses the past tense was, wouldn't a reasonable reader take that to mean that they had a experience and that experience was negative? Isn't that the implicit untruth here, that there was no experience?
I mean,
Go ahead.
No, sorry, Your Honor, I don't want to cut you off.
No, you're fine, counsel. Go ahead.
I understand what you're saying, Your Honor, but the fact is again, and this is sort of getting to distinguishing some of the facts per our specific case, but the manager, and I don't believe this has been disputed at all, and it was stated in the brief to the court, that she went on the day of the incident in her uniform in the shop and spent several minutes criticizing the customers who had come in on Facebook Live, which is the app that has generated kind of all the facts in chief, Your Honor, which are the alleged defamatory statements of all of the defendants, to the best of my knowledge, and basically ran through the entire situation, at which point people were commenting and responding to the Facebook Live video and posting reviews that were negative, saying, I can't believe you're criticizing an autistic child, and all the things that spread from that, Your Honor. So, I mean, who's to say that somebody says, oh, they were rude and awful because they saw a Facebook video, somebody criticizing the customer for using $100 bill that they didn't want to change? It's just, you know what I mean, Your Honor? It doesn't matter whether they were there or not. Anybody can have a negative opinion because they just simply don't like someone for the heck of it. And what we have here is people posting online, and this is supported by Murray v. Pronto Installation, which is a Middle District case. It said the culture of internet communications is distinct from print media, such as newspapers and magazines, and is characterized as encouraging freewheeling, anything-goes writing style, and statements posted online are the repository of a wide range of casual, emotive, and imprecise speech, such that the online recipients of offensive statements do not necessarily attribute the same level of credence to the statements that they would accord to statements in other contexts. So, I mean, what you have here, Your Honor, are many cases, including Home Performance Alliance of the 2nd DCA and U.S. Structural Plywood Integrity Coal from the Southern District, also stating that ratings and reviews are just an evaluating process and a subjective opinion. And there's just—
That's right, counsel. But if we go down to the basics of why we have this protection in the first place, if we assume, as it's Judge Smith said, that it's for the marketplace of ideas, then you combat a bad idea or a bad opinion with another opinion. But when you have a false fact which bolsters an opinion, how do you combat that in the marketplace?
Well, I mean, here's the thing, Your Honor. Regardless of their intent, we're not before this honorable court today to determine whether Oliver and Milligan, the appellees, were right or wrong in posting those opinions. We're here to determine whether the plaintiff has the right to pursue a civil suit against them as a result of doing so. And so the question is to the judiciary, if every time someone posted an opinion on social media, could it be legally construed as defamation? The plaintiff or the appellant here posits a world in which the slightest insult to an unreasonable person would become grounds for a civil lawsuit. And I know the court, this is the classic court buzzword, and you've heard this a million times over, but slippery slope, this case goes to the very heart of that issue. And the outcome of this hearing essentially can help determine how far a party with limitless resources, which in this case is the appellant who owns a law firm and also happened to at one time be an owner of Arita's franchise, is allowed to go to prove its point. Clearly to us, this is a situation where they're bullying anyone willing to dare criticize them.
Well, Counselor, what I guess I'm taking from your statement, Judge Nardella posited a hypothetical that would say, I went to Rita's, owner was rude. If you posited, my friend went to Rita's, which is another fact that's not here, but owner was rude, customer service was awful, would not recommend. That if this goes forward, that we would be placing an obligation on everybody that to affirmatively state where they got the information. And absent that, not only could they be sued, they'd have to go through discovery and every phase of it to prove where their information came from.
That's correct, Your Honor. I mean, that's essentially what's being decided today. And what I hope that we can do today is preserve Justice Holmes' marketplace of ideas concept, which I believe was referred to by Judge Smith earlier, in which the best test of truth is the power of the thought to get itself accepted in the competition of the market. And what happens is you had a manager of a business who made a mistake, and unfortunately for her, that mistake led to bad customer reviews and potentially loss of business. And here we are, Your Honor. But I don't think that's something that should be determined by the court. That should be determined based on the merits of the business and customers willing to partake in that business as customers and provide them their money willingly.
Thank you, counsel. Counsel for appellant with your remaining time.
I'm sorry. Thank you, Your Honor. The manager did not make a mistake because the four corners of the complaint don't mention a manager making a mistake. Who made a mistake?
Let's go back to what we were just talking about, the hypothetical. Under your theory of this case, owner was rude, customer service was awful. If you don't put the background in there to explain why they thought that, you think somebody should be subject to a lawsuit, survive a motion to dismiss, and have to come in and prove all of the facts for why they put that in there.
In part, Your Honor, I believe that with the facts that I have established for my client in this in the pleading here, they are subject to it. In your scenario, it also depends on where they're making their comments. If, as this court is has a video on YouTube, people comment under the video and they know the connection of the video, it's correct to make an opinion on that video. But in this case, on a separate place, they are posting their review saying, my friend went and had this experience. But if the friend's experience was untrue, as we've alleged, it was untrue. There was no mistake by a manager in the pleading. Let that be a discoverable issue. But in this case, it has yet to be proven untrue. What we know is true is that Ms. Martinez and Mr. Moody made misrepresentations, and Ms. Oliver and Ms. Milligan relied on those representations to go and write a review in a separate location than the post that these folks made, in a separate location attacking this business. So in your scenario, Your Honor, if they said my friend's experience was a negative one, customer service is awful, I still believe they could be sued because they would do it in a separate place. If they made that post under the Maria Martinez's or Antone Moody's comment, where then it would be an opinion. They can't be sued. In our case, we don't have that. I'm not asking the court to open the floodgates to suing folks with one-star reviews or non-recommendations. I'm asking specifically in a case where multiple people who are friends and families of one customer write the bad reviews as a result of that incorrect experience. With that, I believe that I presented all the arguments as to why the trial court has made reversible error.
I want to thank all the counsel today. I hope you guys have a happy new year, and we will be adjourned.